There are at times retrenchment compensation has to be paid to employees, so the question arises, what is the taxability of retrenchment compensation in Income Tax Act? Before we discuss, let's understand what is retrenchment compensation under Income Tax Act. Below is the definition. Retrenchment means the termination by the employer of the service of a workman for any reason whatsoever, otherwise than as a punishment inflicted by way of disciplinary action, but does not include voluntary retirement of the workman or retirement of the workman on reaching the age of superannuation if the contract of employment between the employer and the workman concerned contains a stipulation in that behalf, or termination of the service of the workman as a result of the non-renewal of the contract of employment between the employer and the workman concerned on its expiry, or of such contract being terminated under a stipulation in that behalf contained therein, or termination of the service of the workman on the ground of continued ill health. Taxability of retrenchment compensation. Retrenchment compensation is exempt subject to following: an amount calculated in accordance with the provisions of clause of Section 25F of the Industrial Disputes Act, 1947, or such amount, not being less than 50,000 rupees, as the central government may, by notification in the Official Gazette, specify in this behalf. Whichever is less,